Joseph Tartaglia for Philadelphia Mayor, and I'm responding to the Art of Liberation's video. It's in response to my video in regards of abortion policy. You can find the link to their video in the description below, or you can click on the comment to go directly to it. Now let's get into it.
Me and this nice gentleman have been going back and forth, just having a nice discussion about these laws, and character limits were betraying me. So I am on vacation, but I'm at a stop, and so I'm going to make this because I need a break from driving anyway. So it's important to remember that when it comes to the Texas state law abortion restrictions, that their laws constitute a medical emergency. It is only in the life of the mother. So that doctor has to determine, and the law is very vague, if that mother will absolutely die if they don't get an abortion within that very specific time frame.
Based on how it's written, it does suggest that the risk of death is separate from the substantial major bodily function being lost, but I understand how this can be confused. Now, the word or in the context of or arising from is directly based on the risk of death element. You can see that because there's a comma before the word or, stating that it's part of the listing of circumstances for the death risk circumstance. Opposed to the word or in or opposes is now separate from the death risk circumstance. So or being a whole different stipulation. But I do agree, since the doctor doesn't even know if it qualifies, that this can be a very dangerously confusing situation.
Now, this has caused a lot of different trouble. There was a case back in November of this year where 5 women came forward and sued the state, saying we need more clarity on what constitutes a medical emergency, because women are getting into these life-threatening situations because the laws are so vague.
I do agree that there needs to be more clarity on what is qualified, but I don't think it's because it's too vague.
One of the women in this particular case had a fetal scan that showed that her baby was being born without a skull. Her doctor determined that her life was not in danger because the law restricts the abortion access, particularly to the life of the mother. If the mother is going to within the next day or two without that abortion, then that is what they go off.
You are right that the vagueness of the exemption only considers the woman. This does suggest that the baby dying under the circumstances of a failed pregnancy isn't enough for an abortion. And here's why it being more vague can actually clarify this a lot better. And I'm going to show you right now. What about if it was written like this? We would both agree that this does not suggest that the baby isn't qualified, because it doesn't specifically say anything about the rules of what the medical judgment is, because I don't think it should be within the law's decision making to determine that to begin with. But I do agree that there should be more specifications on the legal requirements of this exemption, so I'm going to put something like this in there. Now, this might be good, but I think your next point's going to prove that we might need some more specifications on the legal element.
What's tricky is because these cases aren't criminally prosecuted, they're civilly. If anyone else determined that that doctor made a misjudgment, they could take a civil case before the court and sue the doctor, sue the woman, and this could happen as many times as possible. Let's say 1,000 people heard about this case. 1,000 different people could bring lawsuits against Kate and against the doctor who performed the procedure.
So I do agree that Kate Cox and anyone who wants to get an abortion should be 100% legally safe to do so. But here's the reason why I think the exemption is very dangerous. This exemption implies that Kate, her doctor, and whoever else is involved is completely exempt from the abortion ban altogether. Now, that also includes the exemption from the abortion ban, which means they don't have to follow the exemption. So let's say the doctor schedules an abortion with the clinic for Kate, and the person performing the procedure is drunk and botches Kate's abortion when it leads to serious health issues. She can't sue the negligent person doing the procedure or the doctor because of the exemption that the court gave to her. So basically, this exemption gets rid of any legal recourse that Kate Cox would have had under the circumstance of this negligent act. I understand it's unlikely, but this is a possibility that could have happened and would have led her into a lot of other issues. So back to how to make it so this doesn't happen to her, we'll add something like this. This basically states that she's the only one or her family under the circumstances that she's not able to do it, that can make any legal recourse under the circumstance that there might have been malpractice. This protects her from going to jail. This protects her from getting lawsuits from random people. And this protects her from malpractice.
So doctors are very, very wary, and it's putting women in a very dangerous situation. So the goal is to set legal precedents. So that way, if another woman in her same situation has a baby that's diagnosed with trisomy 18, that way they can look at the legal court cases and say, okay, a judge ruled this way, and so this lawsuit is invalid.
I understand that you're trying to set legal precedents to this, and I also understand that this isn't the case and this isn't what the actual exemption is, so that it's irrelevant. However, trying to sue them over the stipulation that the law is too vague is something that's almost close to impossible to happen. It'll never go down that way. But if you come at it by saying it's too specific, then you can actually show that there's something written down that actually gets in the way of your healthcare rights, making it easier for you to ultimately get something like this. Instead of trying to add precedence to the exemption, you should try to get them to codify the exemption altogether by claiming it gets in the way of your reproductive healthcare rights by saying it's too specific, not too vague.
So a lot of the court cases that you're seeing are actually just women coming forward saying that this is too vague, it's dangerous to women, we need better clarification, and we need better, clear-cut rules on what constitutes a medical emergency.
My final point is that there's a clarification issue, not because it's too vague, but because it's too specific. It's too specific on what it considers reasonable medical judgment and should be left up to the doctor's interpretation based on that medical judgment. Now, I think it should be more specific in regards of the law and legality of the situation, but other than that, I think the vagueness of the stipulation on the actual reasonable medical judgment can actually clarify it way better.
Other thing I wanted to bring up is that I think you're confusing Roe v. Wade with the Hyde Amendment.
This last part's kind of irrelevant. It's about how I confuse Roe v. Wade with the Hyde Amendment, which is probably true, so I'm not even going to argue against that. Well, that about sums it up. I hope this was educational because I definitely learned a little bit from you. I learned that maybe it needed to be a little bit more vague. Now, I'm pretty sure that wasn't your intention, but that's just what I gathered from it. So this has been a very educational experience for me, so I hope the feeling is mutual. Have a nice day.